All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama, these United States. Bless this honorable court.
Please be seated. Well, good morning to all. I'm Chief Justice Tom Parker, and I welcome you here this morning for our oral arguments, which are going to be uniquely here at Jacksonville State. Typically, we hold our oral arguments in the prestigious Heflin-Torbett Judicial Building in Montgomery, but maybe once or twice a year we go out on the road so that you can hear what is your judicial system in action. Briefly, I want to thank those who helped make today's event come together and then introduce the members of the Supreme Court. First and foremost, we wish to welcome all the students who are here in attendance, students of Jacksonville State University. We hope today's court session is educational and inspirational to you as you observe in real time the judicial branch of the state of Alabama in action. This is your Supreme Court. And for those of you who may wish to go on to law school, you may find yourself arguing before this court one day in the future. So pay close attention. We wish to also thank the professors and the JSU administration for letting your students skip class and attend these arguments. To the leadership of Jacksonville State, including President Don Killingsworth on the front row here, thank you for all your gracious hospitality, both last night and this morning. For their welcoming remarks just now, I want to thank the President and presiding circuit judge Shannon Page of the 7th Judicial Circuit, which includes Cleburne and Calhoun County, for all the behind-the-scene work by the excellent and professional staff that coordinated so well with our clerk of the court and other court staff. We thank you, a big thank you to Leah Cauthen, Dr. Lori Owens, Chief Michael Barton, and Captain David Entrikin of the JSU Police, and all the Jacksonville State police officers attending to our safety and good order, both last night and today. From beginning to end, the exceptional team at Jacksonville State has been highly professional and organized, and the success of today's events is largely due to you all and your excellent cooperation with our staff. And now it's my distinct honor to introduce the members of the Supreme Court in order of seniority. To my right is Justice Greg Shaw of Davison. To my left is Justice Kelly Wise of Prattville. To Justice Shaw's right is Justice Tommy Elias Bryan of Brantley. Justice Bryan was recently elected as the Republican nominee for re-election to another term and has no opposition in the general election. To Justice Wise's left is Justice Will Sellers of Montgomery. Justice Sellers was also elected as the Republican nominee for a new term and has no opposition in the general election. To Justice Bryan's right is Justice Brad Mendham of Dothan. To Justice Sellers' left is Justice Sarah Hicks Stewart of Mobile. Justice Stewart was elected the Republican nominee for Chief Justice, and she does have opposition in the general election. To Justice Bryan's right is Justice J. Mitchell of Homewood. Justice Mitchell was also elected as the Republican nominee for a new term and has no opposition in the general election. And to Justice Stewart's left is Justice Greg Cook of Vestavia Hills. As I mentioned, I'm Chief Justice Tom Parker of Montgomery, And as a point of personal privilege, I would like to note that this is my last year as Chief Justice and my last traveling oral argument. Because the Alabama Constitution has an age cap for justices, I'm required to step down at the end of my term in January 2025. It's been a great honor to serve the state of Alabama as your Chief Justice, and like a retiring football coach, I will continue to root for the success of our team, the United Judicial System of Alabama. Okay. And we also have a personal connection with our bench to the university because Justice Brad Mendham's wife is a graduate here, and she's in attendance on the front row. And one of our former justices, Justice Jim Main, his wife was on the board of trustees. Or is she still on the board? She's still. I want to recognize our clerk of court, Megan Rodebeck of Montgomery, who will be calling our case today. And from her staff, we have Chelsea McLaurin. Recording and streaming our arguments today is our hardworking IT team, which today includes Robbie Headley and Jaquil Kemp. Last but not least, we also wish to thank our hardworking marshal of the appellate court, Earl Marsh Jr., and his team, Chief Deputy Chris Coley and Deputy Jason Hilliard, all for their work protecting and serving our courts today and every day. Now, I wish to make a few remarks to mark the significance of today, September 17th, Constitution Day in the United States. Why do we celebrate and recognize Constitution Day? We do so as a reminder of the day it all began in 1787, and to remind us to uphold today the underlying American ideals of truth, God-given rights, equality, and the rule of law. On this providential day in 1787, after a long, hot summer in Philadelphia, the delegates to the Constitutional Convention signed the United States Constitution on September 17th. Many of these founding fathers had fought for independence from Great Britain a decade earlier. Some were drafters of our Declaration of Independence of 1776 and members of the Continental Congress who had sought to create a government that would be founded on those self-evident truths stated in the Declaration. And I quote, "All men are created equal and endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." The Constitution was built upon the Declaration's principles of ordered liberty, equality under the law, and the rule of law, not the rule of men or kings. As the delegates signed the secretive document, Americans in every state waited expectantly to read it for themselves. Just what had the delegates come up with? The famous Benjamin Franklin, as he left the hall of the Constitutional Convention, was asked by a lady waiting outside, "Well, doctor, what have we got, a republic or a monarchy?" Benjamin Franklin replied, "A republic, if you can keep it." As the Constitution was printed and circulated throughout the young United States, men and women throughout the country, lawyers, clergy, merchants, students, farmers, and blacksmiths, read, studied, and debated it in its details among themselves. Those details included the separation of powers, divided among the Congress, the President, and the judicial branch, the few limitations placed on the state governments, the process for amending the Constitution, and the provision that declared that the Constitution is the supreme law of the land. The Constitution was not a long, arduous document, nor was it full of flowery and ceremonial prose. It was and is short, clear, direct, and sometimes boringly technical. The Constitution was not written just for judges and lawyers. It begins by clearly noting who it was for: we, the people of the United States. It was ratified by the people themselves, acting through the several states. It established a constitutional republic and a federal form of government that gave the national government certain limited powers and reserved the rest of those powers to the states and to the people. The preamble of the Constitution expresses why we, the people, ratified it. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. This Constitution will encourage us to establish justice and secure the blessings of liberty. And the amendments that the people later added to it, the Bill of Rights and 17 other amendments, sought to further protect individual rights, enforce equality and liberty, and work toward the ideal of a more perfect union. Our Constitution depends not just on the expert opinions of judges, legislators, presidents, and lawyers. Our Constitution endures when we, the people, when you, the people, read it, study it, cherish it, and if you take an oath to it, to defend and support it. Lastly, I want to remind you that the United States Constitution, signed in 1787, was not the first Constitution in America. All 13 states in 1787, from New Hampshire in the north all the way to Georgia in the south, had 13 constitutions of their own. And many of the features of government and the individual rights that we hold dear were in those original state constitutions. They provided the source material for the drafters of the U.S. Constitution and later the Bill of Rights. Many of these rights provisions were directly copied from the state constitutions of the time. You see, the U.S. Constitution did not appear out of thin air in Philadelphia that summer. Rather, those delegates that gathered brought from the 13 state constitutions and the English common law almost all the principles that we hold dear in our federal Constitution, and especially in the Bill of Rights: separation of powers, freedom of religion, free speech, a free press, the right to bear arms, the right to trial by jury, and the right to due process. Why do I mention the state constitutions? Because not only did the state constitutions of 1770s and the 1780s inform the crafting of the U.S. Constitution and help us understand what the founders meant when they wrote the Constitution, but all 50 state constitutions today still operate to govern state governments. Governors, legislators, judges like us, mayors, police, it just goes on. And to protect your individual rights, often in a greater and more specific way than the U.S. Constitution. Not surprisingly, every state official, attorney, and judge in this building today have taken an oath to uphold the U.S. Constitution and the Alabama Constitution also, and we take both of these oaths seriously. I encourage you to pay attention to the Alabama Constitution too. The first one was drafted in 1819 when we became a state, a generation removed from the founding era. Our current state constitution was ratified in 1901 and again in 2022, and has been amended rather frequently and regularly. As you may know, we here in Alabama excel at college football and amending our Constitution. Our Alabama Constitution may not be as short of a read as the U.S. Constitution, but it is certainly more important to everybody's daily life in this state, including the college students of Jack State. If you are of voting age, then you have the direct power to not just vote for your elected officials, but to amend or not the state constitution at the ballot box. So don't forget to study the amendments whenever there is a ballot, whenever they are on the ballot, and not just the candidates who are running. As Chief Justice, I take seriously the Alabama's Constitution preamble, which is very similar to the U.S. Constitution in that it seeks to establish justice. But our Alabama Constitution preamble makes an important addition when it states, invoking the favor and guidance of Almighty God. Every state constitution has a similar invocation of divine providence. As we turn to the particular arguments in the case before us today, and as you leave after the arguments to return to your dorms or homes, please do not forget my charge to you. On this recognition of Constitution Day, keep the U.S. Constitution and the Alabama Constitution as your own. I know they seem dusty and old, and in parts are hard to understand, but please do not ignore them as the business of only justices and lawyers and politicians. The Constitution is your business. How do we meet the challenge posed by Benjamin Franklin? How do we keep the republic? By remaining a nation under God and under law. Students, do not be content to know some things about the Constitution. Do not be content to just hear public officials speaking about its importance and what it means. Read it, study it, defend it, and if absolutely necessary and proper, then amend it. Because the future of this state and this country depends on you, the people, you, the students, doing just that. So happy Constitution Day to you. May God help us to keep it. And now I want to call on our clerk to call the docket for today.
In case number SC 2023-0784, Shymikka Griggs, individually and on behalf of all others similarly situated, versus NHS Management, LLC. Arguing for the appellant, the Honorable Lisa White, and arguing for the appellee, the Honorable Spencer Person.
Ms. White, you may approach the podium there.
And I also would like to express my appreciation to Jacksonville State for hosting this honorable court and also hosting our oral arguments in this particular case. It's a real honor to be here in front of this crowd, and it's an honor that people are here watching us. Chief Justice, Your Honors, may it please the court. My name is Lisa White, and I'm with Mason LLP, which is based in Washington, D.C. I am here representing appellant Shymikka Griggs in this data breach case against the appellee NHS Management. This case, procedurally, is at its infant stage. It was dismissed in the Circuit Court of Jefferson County on the pleadings, on a Rule 12 motion. And to a very quick overview, June 30th, 2023, Ms. Griggs filed a class action lawsuit on behalf of herself and the approximately 170,000 other people whose personal data was breached in a attack on NHS's computer system. So it's a massive data breach, and private information was lost. In August...
Counselor, you would agree with me that the only thing we have to decide today is a Ms. Griggs claim, right? She's the only one in front of us.
Correct. When she represents, and this may be more for the audience, when a class action is brought in the early stages of pleading, the named plaintiffs represent the entire class, but the named plaintiff has to be a proper party to bring the lawsuit. She filed in June 2023. In August 2023, the defense filed a motion to dismiss, and it was brought under two different sections of the Alabama Rules of Civil Procedure, Section 12B1 and Section 12B6. Ms. Griggs opposed that motion, and in turn, NHS replied to that motion. On October 10th, 2023, the Circuit Court entered a non-substantive order granting the motion to dismiss. And by non-substantive, the court's order gave no explanation why it was granting the motion to dismiss. It was dismissed with prejudice, which put us in a position to appeal to this court. And there was no further explanation.
So to follow up there, it was dismissed with prejudice, right?
With prejudice.
So that meant it had to be under 12B6 rather than 12B1, because 12B1 is a subject matter jurisdiction dismissal. So that would mean that you would dismiss it without prejudice if it was 12B1. So the judge ruled in 12B6 by deduction, right?
Well, no, the words of the order itself said that it was dismissed both under 12B1 and under 12B6, which I agree is somewhat confusing.
But if it's with prejudice, it had to be 12B6.
With prejudice on both.
Right, but you can't dismiss understanding for with prejudice, because standing means you have no jurisdiction.
I think the order actually says that, though. But no,
I don't mean to interrupt you.
No,
we'll
totally
double check, but you can't dismiss understanding if with prejudice.
I think that the main thing about this order was that it was a single paragraph. It gave no further explanation, and I haven't reread it in the last 24 hours, but it said that the defendants.
It just says it was granted.
It was granted,
So
and then granted with prejudice.
Prejudice, yeah.
Yeah,
So I think we can assume she dismissed on the merits.
right. The big issues here. Number one, that procedurally, this is really in its infancy. We haven't gotten into discovery. We haven't gotten into delving into the facts of the case. This is based only on the initial complaint. It was never amended. But the primary questions in front of this court are whether Ms. Griggs is a proper party to bring this matter, to bring the case, and whether NHS has or had a duty to protect the private information it's stored on its computers. If it had a duty, did it breach that duty? And has Ms. Griggs plausibly pled that, this is sort of mixed together, has Ms. Griggs' complaint plausibly pled that NHS breached the duty and that each of her legal claims, has she given enough information, factual information, to support her claims? On behalf of Ms. Griggs and the 170,000 people that she would like to represent in this class action, I submit to the court that the answer to each of these questions is yes.
So let me interrupt you there. The delay that happened is interesting to me. So I'm not seeing any harm that you pled that happened to your client because of the delay in notice. Can you help me there? What harm, if any, other than just the risk of identity theft, any actual harm that happened to her from the delay?
Well, absolutely. So to give the broader picture overall, so the breach occurred between February and May of 2021. There was an 80-day period that the criminal attackers were able to access the documents, the information, the private information in there. And then NHS notified the Department of Health and Human Services, which it's required to do, about 5 months later, and it only began notifying people like Ms. Griggs and the rest of the 170,000 people. It only began notifying them about 10 and a half months later. Now, between the time of the breach and the time that she received notice, Ms. Griggs had a lot of odd things happening. She was getting, she got a call from Apple saying, you know, did you really just buy this $3,000 worth of merchandise? And she hadn't. And so
you allege that was because of the breach, right?
Correct.
But it wasn't because of the delay. It was because of the breach.
Well, at the time that it occurred, she was unaware of the breach. And so she was dealing with this and calls about payday loans that she hadn't taken out and other things. She was dealing with odd events related to her identity.
Or is there any money that she actually lost? Is there I guess we're trying to quantify damages, and you have a claim that says you had a $3,000 charge, and I assume, but did she pay the $3,000? Did she have payday lenders that she had to repay, or what are the damages that we can quantify here? I think that's what we're trying to.
Well, you know, one of the things that your privacy is an injury, you know, having lost your privacy is an injury. And the TransUnion versus Ramirez case is an excellent example about that. The U.S. Supreme Court says there are intangible harms. These are injuries. These are damages that do count as damages, and there are reputational harms. There's disclosure of private information, intrusion upon seclusion, and
Ms. White, but our law. I'm referencing back to the Hinton case from 2001 from our. I'm referencing back to the Hinton case from 2001 from our court. We speak about it in our law in terms of it being a manifest present injury, and I guess the Justice, kind of riffing on what Justice Sellers was asking, I mean, we're trying to get to concretely what's the injury here as recognized by our law?
The injury and again, this goes back to the U.S. Supreme Court's TransUnion case, and I think that TransUnion is an excellent place to start on that because TransUnion was adding information, the very short version. They were adding information, incorrect information, to people's background. There were two groups of people. One, and that case went all the way through a jury trial. One group, the information was on their records, but never released to any person. And that was about 6,000 people. And the other group of 1,800 people, the information was actually released to someone else. So the erroneous information was given to Justice Cook, just as an example. The U.S. Supreme Court said that the first group did not have any injury. The 6,000 people whose documents were wrong, but it was never released to another person. Those people had no injury. But the people who were released to Justice Cook, excuse me for picking on you, that 1,800 did have damages. That was where the line where the U.S. Supreme Court split it. But so the injury occurs when the, let me back up just a second. NHS did not notify every person whose private information was on their computer. They only notified the people whose private information that could be used for identity theft was on their computer. So that information had been released. They are in the group like the 1,800 in TransUnion.
Did Ms. Griggs have false information that was given to other individuals?
Did she have false information?
Well, you had talked about.
Well, TransUnion was a situation.
Inaccurate.
No, it was her accurate information. She had the information of hers that was that was released to the criminals, according to NHS, because that's all the information we have at this point, other than her being notified from outside sources. Her Social Security number, her name, her address, her date of birth, basically all of the information, her health information, the information that was stolen was information that can be used for identity theft. And so once that information is actually released, at that point, she, under TransUnion, she has been harmed. She falls into the 1,800 people.
She might have standing under federal law, but that doesn't answer the question of whether she has damage as an element under the cause of action, right?
Okay, yes.
That's a separate question.
Has she been injured? And yeah, correct.
I also wanted to pick up, she's an employee, right? She was not a patient in it.
She was an employee.
So she didn't have any PHI stolen. She had her employee information stolen.
She apparently did have PHI meaning personal health information. According to her letter, she had health and insurance information that would have been protected.
I hate to interrupt you because I know you've got time, but I just want to ask this that you haven't talked about is, in nowhere in the complaint do you say anything about the Alabama Data Breach Notification Act at all. Can we even look at that as it relates to this, as it was never raised in your complaint, it was never raised in your initial brief and only in your reply brief, or can we dismiss that?
Yes. Number one, we addressed a duty throughout. We addressed the duty to
But you didn't
notify
specifically,
and duty
I just want to make, but you agree with me, you didn't specifically put it in your complaint.
But here's the interesting thing. NHS had a duty under the Alabama Data Breach Notification Law. It had specific duties, regardless of if it was ever mentioned. That's state law.
Okay. Thank you.
Ms. White, thank you. Your red light is on.
Thank you.
And before I call the next party to the podium, let me give a word of explanation to the audience. Each side is allowed equal time in this. But as you just heard, the appellant went first and reserved some time for a rebuttal. So we just had 16 minutes of Lisa White arguing on behalf of Ms. Griggs, and now I'm going to call Spencer Pearson to the podium for his 20 minutes. Mm-hmm.
Thank you, Mr. Chief Justice and Associate Justices. Good morning, and may it please the court. And thank you to Jacksonville State University for hosting us here today and last night. It's been a pleasure. I want to start with reading the words of Ms. Griggs in her opening brief. Admittedly, on page 41, admittedly, if each incident finding her information on the dark web, the Apple charges, and spam communications were standing alone, which it is not, it might constitute an injury in fact. We start here because we can end here. As the justices have already pointed out, in Alabama, under the Hinton case, you require a manifest present injury. In that sentence, she admits she does not have a manifest present injury. And if we walk through them one by one, we see why. First, she received phone calls from Credit Karma. The receipt of a phone call is not a manifest present injury. What did they tell her? Your information is the dark web. It sounds ominous. None of us want our information on the dark web. It does. But the fact that it's out there in the ether doesn't make it a manifest present injury. There are no facts, and under Alabama law, you don't have to accept as true conclusory allegations. You do need to have specific facts in the complaint. And so there's no connection there. There's no traceability when you talk about a call from Credit Karma where you generally say the info is on the dark web. What info? How do you connect it to NHS? Forensic analysts can do that. They can connect it to a specific data breach, and they can tell you whether it's related to this data breach. She doesn't tell us that. Move on to the next one. Lost time with Credit Karma to freeze credit and correct errors on credit report. Again, not a manifest present injury. And here, even based on the allegations that are in the complaint and based on the notice letter that is incorporated by reference, her credit information wasn't impacted. There was no credit card information impacted. There was no bank account information impacted. And so, again, not only is it not a manifest present injury, but it's not plausibly tied to the NHS data breach.
So let me stop you there. Plausibly tied. As you know, our court has not adopted yet and may never adopt the Iqbal-Twombly federal pleading standard, the plausibility pleading standard. We have a very liberal pleading standard here in Alabama. I'm unaware of any case that we've ever tossed on a 12B6 motion to dismiss because of a lack of damage, a fact of damage. So help me. Have we done that before? I know we've tossed some old standing cases that came before we limited the standing doctrine, but I'm unaware of any 12B6 cases we've tossed on the lack of damage before.
I believe you have, Your Honor, and I think it's been in the medical context. And what I am slightly unsure of is the exact procedural posture of these cases. But in the Southern Bakeries case, you had asbestos exposure. And there, the question was, were individuals who were exposed but had not exhibited any sort of symptoms? And that may have been at the summary judgment, and I apologize if it was. But nevertheless, there you had something where persons actually were exposed, but they couldn't state a manifest present injury. And so while that may not have been at the 12B6 motion, I think it is something that you can look to in this case. Similarly, and this one was not cited in the briefing, but Laurel versus Prince, 154 Southern 3D 95 from 2014. There, someone was actually poked with a needle that had been in someone else's arm. And again, there was no manifest present injury based on that. So if in those cases there's no manifest present injury, where there was an actual exposure, where somebody was literally pricked by a needle that had been in someone else's arm, here where it may be that the plausibility standard, and I use that word not necessarily as a term of art when I said it, but more related to the standard that you don't have to on 12B6 accept conclusions of law, and there do need to be facts that are stated with some specificity. I cite it more in that vein, so I apologize if I used a term of art when it was not appropriate.
Mr. Person, you do know that in Alabama law, medical cases have a heightened pleading standard by statute. So those cases are just a little bit different procedurally because of that statute that requires very specific information to be set out in the complaint to get past a 12B6 motion.
Understood. And I used it just as an exemplar regardless, I think that the standard where you're not simply permitted to use conclusory allegations would apply here. I think if you look to some of the other injuries that she articulates as well, there have been courts in this country, in the Ninth Circuit, in the Seventh Circuit, in the Sixth Circuit, that have said an increased risk of harm is enough. But under Alabama's manifest present injury standard, those cases don't survive that scrutiny. Spam calls.
Could I ask you this, though?
Sure.
And I was supposed to follow up some of what the point Justice Stewart was making as well. I may be dubious at this point of her claims, but again, under our notice pleading, shouldn't she at least be able to say, I've circumstantially alleged some events that presumably were not occurring before that are occurring now that seem to go with this data breach? I should at least be allowed to do discovery and find out whether it is from this or not, and then go to the summary judgment phase.
Your Honor, I would say that there still needs to be more specifics in her complaint to be able to move on to discovery, to be able, I mean, she said it herself, NHS was the victim of a data breach. NHS was a victim too. And so where you have such conclusory pleadings where it isn't specific in the complaint as to temporally when these things happened, and it isn't, I was talking about the spam calls a moment ago, even the pleadings in the federal courts that have survived based on increased spam, and usually they haven't survived just on that. Usually there's been something else as well. But even in those cases, there's an allegation that the calls have increased. It doesn't say that in the complaint. It says she receives about 3 per day. I wish I were so lucky.
And again, I'm not that technologically savvy, but I think your client agreed to pay for some sort of monitoring for a year. Was that in the letter?
That was in the letter.
Something about that?
Yes, Your Honor.
So if the argument is, well, nothing's happening now because your client is paying for this service, but then once a year from now expires, suddenly she's going to be at risk, or she would have to spend her own money to continue the service, shouldn't she at least be allowed to do discovery to see if that is occurring? That's been alleged. Again, if I'm not mistaken, I think she attached the letter to her complaint, so that can be considered.
She did, and certainly monitoring was paid for by NHS. That happens frequently in these sorts of data breaches. Oftentimes it's mandated, depending on the state law. And, I think the question is, well, shouldn't she be allowed to allege some sort of injury because she might have an injury a year from now? And I think the question answers itself under Alabama law, which is that's not a manifest present injury. And maybe she will have some cause down the road. We have reason to believe that's not true, but that's outside the plea.
And again, I think some other justices want to follow up, and I'll stop with this, but find an analogy that perhaps I'm more familiar with outside of the technological aspect. But say I'm in a car wreck, and so I want to sue the person who hit me, and I'm alleging that my damages are now I'm having headaches, and I wasn't having headaches before. Of course, the response is going to be from the defense that, they didn't cause my headaches from this wreck, but presumably I would still survive a motion to dismiss. And I can't say whether your client caused it. All I know is that temporarily, this is what is occurring. Any distinction with that type of analogy? And then I'll stop and let some other justices follow up. Sure.
Well, in that situation, I think you'd be allowed to proceed as an initial matter based on the car wreck and the damage caused by it itself. And then you would be able to get into.
I'm assuming there's no other damages.
Oh, okay.
Let's say, I didn't have any other physical injury or property damage.
Right. I mean, in that situation, it seems to me that it would be a clear medical injury that you're alleging happened after the fact and was not happening before. And
it seems to be that's what she's alleging now, is that there's these events happening that weren't happening before.
I'm not sure it's that clear in the complaint, number one. Number two, here, it's still conclusory in that she's not tying the allegations to NHS. When she alleges a credit injury and her credit card information was not impacted, when she alleges an Apple injury where they couldn't possibly know whether she was an Apple customer, and by the way, by calling her, that's probably the fraud department saying we're not going to let this charge go through. And so there wouldn't be an injury there. One would be a physical injury. She is not alleging a physical injury. She's alleging some sort of future economic injury, and I think that's the distinction, and that would be the distinction.
Counsel,
Yes.
is it your position that as a matter of law, there is no set of circumstances under which the plaintiff could recover?
Well, let me say this. There are data breach cases where there certainly is an injury that would be a manifest present injury. That's just not the case here. So there are cases where common early on in the bad guys over the internet sort of business that they're in, where there were W-2 phishing scams. And in those instances, folks had fraudulent tax returns. If it was apparent just from their W-2 that they would receive a refund, they had fraudulent tax returns filed in their name. That's an economic injury. Also an economic injury that they probably had to hire an accountant or a lawyer to clear it up. So in that instance, yes, I've handled cases where folks through a wiring phishing scam have had their entire deposit on their home stolen. That is absolutely a manifest present injury. So no, I'm not saying there's no circumstances where there wouldn't be an injury here. And certainly a Social Security number was involved, and we recognize that. And there have been cases in other circuits that have said that that information does lend oneself vulnerable to a possible future injury, but that they do not have the 12B6 standard that you have here in Alabama of a manifest present injury.
So if I'm hearing you correctly, what you're saying is you don't know whether she has suffered an injury or not.
We know she hasn't pled one.
Okay, well, that's where I'm going. I think that's what's concerning the court. In Alabama, we have a very, very liberal pleading requirement, and we call it notice pleading, where it has to be sufficient to at least place the other party on notice of what you're trying to do in this litigation. But the standard, the 12B6 standard, speaks in terms of whether the plaintiff could, giving all deference to the allegations in the complaint, are there any circumstances under which the plaintiff could possibly prevail? That's a very, very broad standard. If we don't know, I think you mentioned a couple of times that she didn't specifically allege some kind of connection between, what occurred and an injury. Wouldn't that be what discovery is for? To discover what happened, when it happened, who it happened to. So that's what I'm concerned about. Are you saying that, I don't hear you saying that you've been denied due process because of the vagueness of the complaint. I hear you talking about a certain plausibility pleading standard that you're saying we're bound by. But I really need some help on that.
Sure, and I recognize the liberal pleading standard, but it doesn't require courts, district courts, this court, to check common sense at the door. And there still needs to be an allegation that there is a connection to the damage. And so, again, Credit Karma, a phone call, that it might be out there in the dark web, not a present injury, information where she's talking about potential credit injuries, whether it be through Apple fraud, whether it be her monitoring her financial accounts weren't impacted. And so I do recognize the notice pleading standard. On some level, we were already on notice because we gave her notice through the letter. So we certainly know that the data breach happened, but I don't think that the courts have to say that no case can be dismissed if there aren't facts pled that would lead you to believe there was an injury. It would be a little like in a personal injury case where there was a puddle in a grocery store on the floor, and you allege that you were at the store at that time, the puddle was there at that time, you even stepped in the puddle. All those things are, i.e., she received a notice letter, but you don't allege that you slipped and fell. I mean, that's the last thing that you have to allege, and she just doesn't allege it.
Would you like to respond to counsel's discussion of the TransUnion case and her division out of the 6,000 and the 1,800 in the information? Would you like to address what her comments on that?
Sure. TransUnion, she correctly says there was 2 buckets of folks. There were the folks that had their information transmitted to a third party, and there was those that did not. And here, she has not given an indication in her pleadings that this information has been transmitted to a third party, because these damages cannot be logically connected to the NHS breach. And so is NHS's position that she is much more akin to those folks who did not have their information affirmatively disclosed than she is the other. And that goes to her breach of confidence and her invasion of privacy claims as well. I mean, those claims require an affirmative disclosure. There is none here. I mean, again, NHS was a victim of a data breach.
I want to ask about the duty issue, because this concerns me a lot. I have not believed that there's a duty that's been breached, because there's a criminal act here and an employee is involved. And so unless there's specialized knowledge that's probably going to be a criminal activity, Alabama law generally doesn't impose a duty. But after you knew about the breach, you had 10 more months and you didn't tell anybody. At that point, you did have specialized knowledge that there was probably going to be additional criminal activity, because you wouldn't steal the data unless you were going to use it as a criminal. So tell me why there wasn't a duty on you after the breach to notify Ms. Griggs.
Well, that's a statutory obligation under the Alabama Breach Notification Act. And so there absolutely was a legal requirement to do so. And we did do so.
I'm sorry, you didn't notify her, did you?
We notified her of the data.
10 months later.
Sure, yes.
Right, so the delay, you breached your duty, not timely delaying in notifying her. I'm not even talking about the data breach statute. I'm just talking about a common law duty, because once you knew there'd been a breach, you knew that a criminal had the data. You had specialized knowledge that a criminal had data, and they were likely to do additional criminal stuff. So why didn't you have a duty then, even under the common law, to tell Ms. Griggs?
Sure. And I think that there's 2 answers.
Did you know that a criminal had the information? We're making an assumption that a criminal had the information. Do you know for a fact the criminal had the information?
We know that a criminal had access to the information. I don't want to venture too far into facts here, but there are 2 types of cases, and this is one reason why I quarrel with a portion of your hypothetical, which is that, and that this reasoning, haunts me on a daily basis. Out of the 7th Circuit and the 6th Circuit, there are a couple of cases that say, why else would someone go in and steal information but to use it piece by piece, person by person? And 9 out of 10 cases I have today are ransomware cases. And the answer is, well, they're not doing that. They are getting a lump sum up front, like we all would like if we win the lottery. That's what the option we'd choose, and that's what they're doing too. They're not going piece by piece, person by person, charging $2,000 at a time, creating this compendium of information that they can use. They either get all the information up front, sell it for a huge amount of money, or a ransomware. And so I quarrel with that front end there as well. But I see my time's winding down, and I lost the other portion of your question.
Why wasn't there a duty under the common law to notify Ms. Griggs and not wait for 10 months? I mean, that's a long time, counsel.
So now the waiting part, again, we're going to stray into the practicalities of this, but it's not like folks are sitting on their hands. Usually when someone has intruded into a system, it takes a copious amount of forensic work to figure out what data was impacted, how it was impacted, then compile that into a list, merge it all together. This is not a short timeline. And so I know that we've heard of, the foreign like GDPR and things like that, where you got to notify on the head of a pin, and it's rarely that clean. It's rarely that clean. The only cases where it would be close to that clean would be in the W-2 cases, where there's a very small number of folks that were impacted and they were employees and things like that. Well, thank you very much. Oh,
do you have, this is outside of the record, so never mind, it's outside.
Well, thank you very much. I see my time has expired.
Thank you, Mr. Persons. And as I explained earlier, the appellant goes first. She reserved 5 minutes for her rebuttal. So, Ms. White, it's yours again.
Thank you. Let me hesitate for just a second there were several ideas that I had that were addressing the things that you've just brought up. The question of whether Ms. Griggs' information was transmitted to a third party or not, that is information that NHS provided to her when it sent her a notice letter. That's not a question. I mean, at least from our part, the letter that they sent her, which is included in the complaint, did say that it was transmitted to a third party. So she is in the 1800 bucket. The other issue that keeps bothering me here is this idea of not even getting to discovery. The complaint was written when Ms. Griggs' attorneys, our firm, was aware of that she received a notice, that she'd had all this flurry of identity theft happening to her, and that she was having to put it out like whack-a-mole. I mean, this is happening and then that's happening. It doesn't require, contrary to defendant's argument, you don't have to have a person's financial information in order to steal their identity. Your identity is tied so heavily to your name, your date of birth, your Social Security number. And once you get those, you can open an Apple account. You can charge $3,000 saying, my name is Lisa White, my date of birth is this, and whatever else. I mean, it doesn't require that anything about an Apple account is released. She also had payday loans that she's been trying to disavow. She never took out a payday loan. And yet her information has been used to take out payday loans.
Just be clear, they were a victim of a crime, right? And NHS was a victim of a crime. Someone hacked their system illegally, right?
Someone was able to hack into their system.
So I'm having problems finding a common law duty for them at the breach stage. Under our case law, I don't see that. So to me, the common law duty might be their delay, and I don't see the damage to your client that you pled from the delay. So help me understand what happened because of the delay.
Okay. Well, she didn't have just a common law duty, or NHS didn't have just a common law duty. The Data Breach Notification Act does include a duty to protect, a duty to secure its systems.
But our act says it doesn't ever modify the common law ever, right? That's what it says.
It doesn't. I'd have to reread the exact wording, but it does not foreclose tort claims.
Nothing in this chapter may otherwise be construed to affect any right a person may have at common law. How much more clear could it be that it can't be used for your cause of action? It doesn't affect any right at common law, is what it says.
I think the responsibilities that NHS has does not reduce Ms. Griggs' rights, but it doesn't replace if you have a tort claim,
you're short on your time. Just
okay.
If you can be precise, what damage was there from the delay? What do you think the damage was from the delay?
Damage from the delay is that she did not have the opportunity to close down her accounts, to freeze her accounts through the credit monitoring because she didn't know why all this was happening.
And that caused what?
And that caused her to have charges against her on Apple, which she only learned because of the Apple call from fraud. It also, we don't know if her payday loans are going to be demanded against her. They're not her payday loans. The loans taken out in her name using her Social Security number. So, anyway, my time's up.
Thank you, Ms. White. Now, for the audience, we will take this case under consideration, and we thank the counsel for the arguments, and with that, we stand adjourned.
All rise. Court is now adjourned.